Hello and welcome to A Bit Too Much to Think. Today is the very first episode in a series of episodes explaining why sovereign citizens are wrong. Now, if you're like me, you may have seen videos of sovereign citizens getting the crap beat out of them by cops, getting arrested and stuff, and saying a lot of weird things, like saying the People versus Battle, Thompson v. Smith, Black's Law Dictionary. And you might have wondered, what do these things actually say? Now, if you're not familiar with sovereign citizens, they're essentially a group of people that believe in some really weird things. Like, they're like libertarians taken to the nth degree, but they also quote really weird and piecemeal law that they claim gives them the right to break the law, including the biggest one is that they drive without a license, and then they say that you don't need a license to travel, and driving is only commercial. So, I wanted to start a series of videos on why they're wrong. If you're not familiar with sovereign citizens, one of my favorite YouTubers, Donut Operator, he has a bunch of videos on sovereign citizens. He plays sovereign citizen bingo. It's a lot of fun to watch. They're pretty long live streams, but they're really fun. A lot of fun to join in and watch, and even looking back on it. So, today is the very first video. I'm going to be going over Black's Law Dictionary, because that's one of the most commonly quoted. So, the very first thing, what is Black's Law Dictionary? So, it's a dictionary. That's what it is. It's a source of interpretation for lawyers to use when they're creating their cases. But let me be very clear, Black's Law Dictionary is not law. It is not a legal authority by any means. It does not set precedent. It does not create law. It is not a legal authority. It is not an act. It is not anything that has ever been passed. It is just a dictionary. Alright? So, when people say, oh, Black's Law Dictionary defines driving as used commercially and traveling as just for personal purposes. So, here's the first thing. Black's Law Dictionary isn't law. It doesn't matter what it says. It matters what the law says. But here's the second thing. Black's Law Dictionary doesn't actually say that. Let's first look at it. So Black's Law Dictionary, I'm just using the online dictionary. It defines driving as one employed in conducting a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or a bicycle, tricycle, or motor car, though not a street railroad car. So then it says, look at Davis v. Petronovich in 1896 in the Alabama Supreme Court. So, let's look at that definition again. Driving is just conducting a vehicle, right? Though not a street railroad car. So I guess if you're gonna steal one of the street cars that they still have in San Francisco, you can go ahead and do that without a license. I think you're okay. There's other legal issues that you're getting into with that. But let's look at Davis v. Petronovich in 1896. So basically, the summing up of this case is a guy with a bike was forced to pay a license tax. And they basically just said, you don't need a license to ride a bike. And this is quoting from the case. The bicycle owned by appellant does not belong to the class of vehicles upon which the city of Mobile had the authority to levy a license tax. Now, the argument made by the guy who owned the bicycle is that he was just using it to go about his daily life. And they're like, that's not really the issue that we're dealing with here. They say in the Supreme Court, regulation may be by license, and that includes all vehicles. And then they also say that the license may be exacted of vehicles dangerous from any cause. So, essentially it says two different important things. Is that they can regulate by license. Now, whether or not they have the authority to levy a tax is a little iffy. But it also says that any license may be exacted of vehicles dangerous from any cause. So, cars are dangerous. Dangerous things can be regulated for the sake of public health and public safety. I mean, that's something that's been repeated throughout every single court case. But what's really interesting about it is that it says that dangerous vehicles, which are cars, there may be a license exacted, and it doesn't say that you don't have the right to levy a license tax. So, you could make the argument, oh, well, you have to pay for a license. Like, I had to pay like $25 to get my new driver's license for the state I moved to. But that's actually allowed, and it's legitimate. So, That's why they're actually wrong there. It defines driving as one employed in conducting a coach, carriage, wagon, or vehicle. It basically says nothing about commerce. Now, here's the interesting thing. It says employed. Now, you could say employed, that means you're working a job, right? Wrong. So, employed, according to Black's Law Dictionary, basically means doing a thing, because it quotes U.S. versus Morris in 1840. So, U.S. versus Morris is a case where essentially they were trying to decide whether or not someone who was on a ship going to go get slaves from Africa was actually participating in the slave trade, or, well, whether or not they were employed in the slave trade. And what they basically come to the conclusion of is, if you are doing it and you know what's going on, then you are employed in that thing. And so, really what it means is, if you know that you're driving, if you know that you're going to go do something, well, So really what it means is, let's take it back from driving, just, if you know you're going to go do something, and you know its purpose, then you're employed in doing it. And so, if you could say that for driving. If you're going to go operate a motor vehicle, and you know that driving it is operating it, and which obviously that's the only way to operate it, then you are employed in doing it. It has nothing to do with commerce. It does have something to do with commerce in U.S. versus Morris, because it quotes stuff about, like I said, the slave trade, stuff about the whaling trade, but really the core argument of it is, if you know what's going on, then you are doing it. That's basically what the case comes down to. So, if you know that you're driving, then you are driving. If you know that you are conducting a motor car, then you know you are driving. That's why sovereign citizens are wrong on Black's Law Dictionary. Just one more quick thing to add. I just saw a video where this lady claimed that Black's Law Dictionary defines crime as there having to be an injured party. She also keeps repeating the term corpus delicti, so I thought I'd clear those two things up. First off, Black's Law Dictionary does not define crime as an injured party. It actually says a crime is an act committed or omitted in violation of a public law, either forbidding or commanding it. So there you go. There doesn't have to be an injured party. Also, corpus delicti. So this is just directly from Wikipedia. Corpus delicti is a term from Western jurisprudence referring to the principle that a crime must be proved to have occurred before a person can be convicted of committing that crime. The key word here is convicted. A cop is not the person that is convicting someone of a crime. That's what the courts are for. That's what the juries are for. That's what the judges are for. That's what the lawyers are for. You can be arrested, and it does not mean you're being convicted of a crime. So corpus delicti does not even remotely apply when it comes to a traffic stop. Thank you very much for listening, and have a wonderful day.